Hello, my name is Ryan Barrick, and I'm an attorney with the Tampa Bay law firm of Kwall, Barrick, Nadeau. I'm here to speak with you today about issues of COVID-19 and employee rights. Today's date is March 30th, 2020. And again, my name is Ryan Barrick. I'm an employment lawyer, a board-certified employment lawyer with the law firm of Kwall, Barrick, Nadeau, and our website, employeerights.com. And I'm going to talk with you today about issues associated with employee rights. What are we going to talk about? We're going to talk about the Families First Coronavirus Response Act, the FFCRA, the addition of paid sick leave, the expansion of the Family Medical Leave Act, the expansion of unemployment benefits available under the recently passed CARES Act, and the application of existing employment laws to the current COVID-19 issues. This presentation is for informational purposes only. We are not acting as your attorney, and this should not be considered legal advice. Your individual situation may require a unique response. Also, everything is rapidly changing. First thing I'm going to discuss is paid leave under the Families First Coronavirus Response Act. The FFCRA just flows off the tongue, doesn't it? The FFCRA was passed by Congress to provide paid sick leave and paid expanded family and medical leave. It goes into effect on April 1st, 2020 and ends on December 31st, 2020. This is the first nationwide paid leave act. The Families First Coronavirus Response Act covers most public and private employers with fewer than 500 employees. Employers of healthcare providers or emergency responders may elect to exclude such employees from eligibility for the leave provided under the Act. The law also allows for intermittent paid family leave if the employer agrees, so it does not necessarily require the leave to be taken in large blocks. This is similar to the Family Medical Leave Act, which also provides for intermittent leave. There are three categories of paid leave. The first category is that an employee can take 2 weeks, up to 80 hours, of paid sick leave at their full rate of pay if the employee is unable to work because the employee is quarantined due to a government order or on the advice of a healthcare provider, or the employee is experiencing COVID-19 symptoms and seeking a diagnosis. Again, that employee can take up to 2 weeks of paid sick leave at their full rate of pay. The second category is an employee can take 2 weeks, up to 80 hours of paid sick leave at 2/3 of the rate of pay if the employee is unable to work because of the need to care for an individual subject to a quarantine or to care for a child whose school or childcare is closed due to COVID-19. That's the family portion of it. The last category is an employee can take an additional 10 weeks, so a total of 12 weeks, but an additional 10 weeks, up to 40 hours a week of expanded paid family and medical leave at 2/3 of the rate of pay if the employee is unable to work due to a bona fide need to care for a child whose school or childcare provider is closed due to COVID-19. So that's an additional 10 weeks. So it's 2 weeks plus 10, that's a total of 12 weeks. The 2-week period of leave is available to all employees, regardless of how long they had worked there. The additional 10 weeks of paid expanded family and medical leave are available to all employees who've worked for at least 30 days. If an employee is able to telework, they will not be entitled to the additional paid leave. The full paid sick leave is calculated using either the employee's regular rate of pay or the applicable minimum wage. The current applicable minimum wage in Florida is $8.46 per hour. So you use either the employee's regular rate of pay or the minimum wage, but there's a maximum daily of $511 and a 2-week maximum of $5,110. The 2/3 sick leave is calculated using either the employee's regular rate of pay or the applicable minimum wage, whichever is higher, up to a daily maximum of $200, a 2-week maximum of $2,000, and a 12-week maximum of $12,000. What about small businesses and this new COVID-19 Leave Act? Unlike most other employment laws, this law covers even the smallest employers. However, small businesses, fewer than 50 employees, may qualify for an exemption. The exemption is only for leave based on school closings and childcare unavailability, and only if the leave requirement would jeopardize the viability of the business. There's also a dollar-for-dollar reimbursement through tax credit available to all employers. So again, I want to emphasize that. There's a dollar-for-dollar reimbursement through tax credits available to all employers. The Department of Labor will be issuing regulations. This law, like many others, is really going to be guided by those regulations. Those regulations are expected to be released sometime in April. They'll provide further guidance on who is covered, when the FFCRA applies, and how small businesses are effective. For example, the Department of Labor currently states that certain provisions may not apply to certain employers with fewer than 50 employees. The DOL has issued a question and answer document which addresses some, but not all, of these issues. What if my employer refuses to give me leave? Under the FFCRA, it is unlawful for an employer to discharge, discipline, or otherwise discriminate against an employee who takes paid sick leave under the FFCRA and files a complaint or institutes a proceeding under or related to this law. So how do you deal with this if your employer refuses to give you leave? You can file a complaint with the Department of Labor. Their telephone number is 1-866-4-US-WAGE. Again, 1-866-4-US-WAGE. You can file a lawsuit in federal court for the sick leave claims. The paid leave claims, and so this is the difference there, the 2 weeks sick leave versus the 10-week paid leave claim. The paid leave claim against employers with less than 50 employees appear to only allow for complaints to be filed with the Department of Labor. Paid leave claims against employers with more than 50 employees allow for private lawsuits. Of course, this all assumes that the employer is continuing to operate, which is a big question in many employment situations right now. So the Coronavirus Aid, Relief, and Economic Stimulus Act, which is the most recently passed law, had important changes with respect to the unemployment system. In Florida, this system is known as reemployment assistance. Unemployment benefits vary greatly state by state. And again, in Florida, this system is known as the Reemployment Assistance Act. In Florida, the maximum normal benefit is $275 per week for a total for 12 weeks for a maximum benefit of $3,330. It only applies to employees who are terminated for something other than misconduct. It does not cover independent contractors. Under Florida law, the number of weeks of benefits increases based upon the total unemployment rate. But the CARES Act, the Coronavirus Relief and Economic Securities Act, the CARES Act, passed by Congress and signed into law last week, provides for additional unemployment benefits. It provides an additional $600 per week on top of the state benefits. It also provides an additional 13 weeks of coverage, up to a total of 39 weeks, depending on the unemployment rate, which will likely, again, increase in Florida. It also allows coverage for people typically left out of the unemployment system: independent contractors, freelancers, gig employees, self-employed, part-time workers. Coverage for those who are unemployed because they're sick, caring for the sick, quarantined, or home with children because of COVID-19. Under the prior system, the normal unemployment system, if you are sick and unable to work, you're not entitled to unemployment benefits because the goal of the system is reemployment. Here, the goal of the system has been modified slightly to provide a means to provide benefits to people so that they can keep living. And so it's really a different kind of system and a different focus. It applies to individuals who are already on unemployment for unrelated reasons. So if you're currently receiving unemployment benefits, you will be entitled to the enhanced benefits. The additional 13 weeks and $600 may also apply to those who've recently exhausted their benefits. States like Florida are being incentivized to waive the normal 1-week waiting period. People who can telework or are receiving paid leave are expressly excluded. You can't double dip. You can't get the unemployment benefits and receive the paid leave. Now, there are a number of existing federal and state laws that are also out there that are going to be impacted by people who have these issues and by the coronavirus and by COVID-19. I'm going to try and talk about some of those. I want to again take a moment to explain that my name is Ryan Barrick. This is a presentation about COVID-19 and coronavirus and how it impacts on employment law issues, and employment law issues impact on it. My focus is on employee rights. This is not legal advice. Circumstances are changing rapidly. Today is March 30th, and so there's a likelihood that whatever I say today may be different tomorrow or at some point in the future. So this is not legal advice. Your individual circumstances may dictate a different outcome or that you do something different. You're urged to consult with an employment attorney in your jurisdiction. I'm going to talk a little bit about the existing employment laws and how some of these are impacted by COVID-19 and the coronavirus. First one that we're going to talk a little bit about is the OSHA, the Occupational Safety and Health Act, OSHA, the Occupational Safety and Health Act. Interestingly, OSHA is enforced by the Occupational Safety and Health Administration. So both the agency and the law have the same abbreviation or acronym, OSHA. There are no specific COVID-19 related standards. However, there are PPE, personal protective equipment standards, which require gloves, eye and face protection, and respiratory protection for those who are in contact with people who have been exposed to COVID-19. OSHA also has, and really this is the most important part with respect to OSHA, is what's called a general duties clause. And that's the duty that all employers have to provide employment and a place of employment which is free from recognized hazards that are causing or are likely to cause death or serious physical harm. That's, again, the general duties clause. And so in this environment, the general duties clause would mandate that employers follow the CDC recommendations, the 6-foot spacing, the providing wipe downs of frequent touch points, ensuring that employees are being provided with a safe working environment. Complaints under the Occupational Safety and Health Act are investigated by the agency, OSHA, the Occupational Safety and Health Administration. There's no private right of action under OSHA. So if you have a complaint, you need to file it with OSHA. The Family Medical Leave Act. Again, one of the main laws that in the normal course would govern leave is the FMLA, the Family Medical Leave Act. So for those employees who are not covered by the FFCRA paid leave provisions, the regular FMLA leave may be available. This would include employees who work at employers that have more than 500 employees. The FMLA applies if you work for an employer with 50 or more employees within a 75-mile radius and you've worked there for 1 year and worked at least 1,250 hours. You may take unpaid leave. Again, the FMLA is unpaid leave. You may take unpaid leave to care for your own serious health condition or to care for a family member who has a serious health condition. Previous use of FMLA leave does not prevent use of FFCRA leave, but the maximum leave entitlement for FFCRA or FMLA is 12 weeks. It's not an additional 12 weeks. It's 12 weeks total. So if you've used some of your FMLA, you still have availability of the sick leave portion, the 2-week sick leave under the FFCRA, but the paid leave portion, you don't get an additional 12 weeks. Another law that's out there that's important in this context is the Americans with Disabilities Act. The Americans with Disabilities Act prohibits discrimination against employees who have a disability, are perceived to have a disability, or are associated with someone who has a disability. The ADA provides that disabled employees must be given reasonable accommodations. It applies to workplaces with 15 or more employees. Now, employers may ask their employees if they are experiencing COVID-19 symptoms. symptoms. This would generally be considered a medical exam, but because of the unique circumstances of this outbreak, employers may ask about their symptoms and may actually take the temperature of an employee to determine whether or not they are currently suffering from COVID-19. A doctor's note may be required to return to work if an employee becomes ill with COVID-19. The Civil Rights Act of 1964, Title VII of the Civil Rights Act of 1964, is a law that prohibits discrimination based on race or national origin. It would apply if an employee of Asian descent, for example, is being treated differently because of COVID-19's original origins in China. And if they were discriminating against Asian employees, that would be unlawful. Title VII of the Civil Rights Act of 1964 is enforced by the EEOC, as is the ADA. Both the ADA and Title VII require that employees file a charge of discrimination with either the EEOC, the Equal Employment Opportunity Commission, or what are called FEPAs, Fair Employment Practices Agencies. FEPAs include the Pinellas County Office of Human Rights, the City of Tampa Office of Human Rights, the Florida Commission on Human Relations. Prior to bringing a claim under Title VII of the Civil Rights Act of 1964 or the ADA, you have to file a claim with one of those agencies. The FMLA does not require you to file a claim with an agency. You can just file a lawsuit. Another law I wanted to mention is the National Labor Relations Act, the NLRA. The NLRA protects employees their right to engage in protected concerted activity. What does concerted activity mean? That means employees are working together to improve their wages, benefits, and working conditions, and engaging in union activities. The National Labor Relations Act applies to union and non-union employees in the private sector. Managers are not covered. The National Labor Relations Act is paralleled by the Federal Labor Relations Act, which governs federal employees, and the Public Employee Relations Act in Florida, which governs state of Florida employees. They all focus on whether or not employees are engaged in concerted activity, which means working together to improve the wages, benefits, or working conditions. Working together is really the element that is so important under the National Labor Relations Act, that concerted activity, advocating not only for yourself, but for your coworkers as well. So one issue with the National Labor Relations Act is union management are facing unique situations which are affecting bargaining agreements. So if it is a unionized workplace and there's a collective bargaining agreement, those frequently have provisions in there about how layoffs are being conducted, rights of employees, bumping rights, severance agreements. Those agreements continue to exist and are in force, and the employer and the employee have agreed that those are how we're going to deal with those things. Now, for non-union workplaces, where the NLRA can be an issue and a real benefit for employees is non-union employees can come together, petition to their employer to make certain changes, safer workplaces, teleworking, wages, which would bring them within the protections of the NLRA. Again, the focus of that is, are you working to try and advocate for the collective, the group? That's really the focus of the National Labor Relations Act. I want to mention that the National Labor Relations Act, like some of these other laws, does not have a private right of action. And if you want to bring a claim under the National Labor Relations Act, you need to file a charge with the National Labor Relations Board, the federal agency that has the ability to investigate claims under that law. These are only some of the employment laws that are currently protecting employees. There are many other laws that we didn't discuss today, including state and local laws and local ordinances that may apply. What I think we're seeing is this is a rapidly evolving situation. There are changes that are coming down the pike, and everything is different than it was 3 weeks ago, and we're going to continue to see changes as society adjusts over the short term to really what is a global pandemic and is really making a huge impact on all aspects of our life, employment and everything else. I want everyone to remain safe, practice social distancing, keep your thoughts on how it is you can protect yourself and your family. We will get through this. We will get through this together. Be safe, be thoughtful, take your time, and do things that make sense to protect you and your family. My name is Ryan Barrick. It's been my pleasure to talk with you for the past 20 minutes or so about some issues associated with employment law and COVID-19 and the coronavirus. We're going to have a post on our website, and I will be taking questions. If somebody has a question, I would try and answer it as best as I can. But we will also be putting an update on employeerights.com with some of the links to these laws and answering questions that we can and providing additional updates. Again, if anyone has a question, I'm going to happily try and answer it. So I'm not necessarily seeing questions. If anyone has one, you can try and answer it. You can also contact us. So generally, the question is, I'm a salaried employee furloughed 1 day a week. Am I entitled to file for unemployment? So first, I want to mention that my advice is really limited to Florida law. I'm not in a position to provide advice on other states' laws. So you should consult with an attorney in your own state because the laws vary from state to state and jurisdiction to jurisdiction. Under Florida law, you probably would not be entitled to unemployment in the normal course of events for a 1 day furlough because there wouldn't be a substantial difference in your compensation. With that said, our general advice in these circumstances, if you're unsure or unaware, you should consider applying for unemployment because the system is evolving and changing, and we really don't know how many of the things are going to be dealt with by the adjudicators. And the adjudicators are the people who actually make the unemployment decisions. So in the normal universe, I would say that someone who is being furloughed for only 1 day a week is probably not normally entitled to unemployment benefits. But under this current law and current regime, we really don't know how that's going to play out. It is a rapidly evolving situation. Again, different laws, different states, and so I want to be mindful of our general advice in these circumstances is things are changing rather rapidly. When in doubt, apply for unemployment benefits. Of course, you want to make sure that you are being truthful in your application because that is an application given under oath. So you want to make sure you're providing complete information in your application for unemployment benefits. In Florida, you apply for unemployment benefits online. The system is somewhat overtaxed right now. It wasn't good before, and now with the COVID-19 and coronavirus issues, it's really overtaxed, and that's a problem. They're trying to bring it up to speed, but it wasn't really a focus of the government in the recent past, which is shown by the relatively small amount of benefits and the inefficiencies in the system and the lack of support for the system. So now that we've got an emergent situation, it's really having some problems dealing. Best you can do is just apply, keep trying the website, and keep following up. If anyone else has any other questions. So again, the question is about a shelter-in-place law. The state has a Shelter-in-Place Act. Small business that is required to travel to the employer's site, and the business is not essentially functioning right now. So Our general advice right now is people should apply for unemployment benefits, and that applies in most circumstances. If you're not working, you should apply for unemployment benefits because the law is rapidly evolving and changing, and it's really designed to provide benefits for employees. So if you're in a situation, and again, I can only provide advice as to Florida law, and this is not legal advice, this is rather a general statement that under the current environment, our general advice is to apply for unemployment benefits if you believe you could be eligible. Make sure that you are providing truthful information in response to any of the inquiries, and let the system play out. Under the new law, you should be entitled to benefits if you are unable to work because of the COVID-19 or coronavirus. If you're unable to work, you should be entitled to benefits. And again, the new law includes people who normally wouldn't be entitled to benefits, people like independent contractors. Those people normally wouldn't get unemployment benefits, but in this COVID-19 environment, they are eligible for unemployment benefits. So our general advice is, if you think you could be eligible, you should apply. You should be mindful of the requirements to be honest and truthful in your answers, and you really want to make sure you're doing that. Now, if anyone else has another question, I'm happy to try and answer. Well, again, it's been a real, I don't want to say pleasure. It's been a difficult time for all of us as we try and adjust and adapt to a changing environment, a changing work environment. I encourage everyone to remain safe, to keep a positive outlook. I think we will get through this. I think our environment, our country will get through this. I think our employment situation will get through this. We just need to sort of keep trucking along. We're all in this together. Do the best that we can and try and be as thoughtful as we can as we interact with everyone, and realize that most people are really trying to do their best as we confront a very, very difficult situation. Again, my name is Ryan Barrick. There will be a link at employeerights.com, which is our website, employeerights.com, to the information about some of these laws. If you have additional questions and you're in the Tampa Bay, Florida area, I would certainly encourage you to contact us. If you're outside the Florida area, you should contact a lawyer in your jurisdiction who can provide you advice on legal issues and how they impact you and your local laws. Again, Kwall, Barrick, Nadeau is our firm. Employee Rights is our website, facebook.com/KBNLaw, 727-441-4947. You can also email us at info@employeerights. I hope that everyone remains safe. We have positive views for you and positive thoughts that we're sending out, and it's a tough time. And it's been a crazy 3 weeks. I don't know what else to say other than that, but please stay safe, and if we can help you in any way, please reach out. Have a good day.